a submission of no case. Indeed, the court gave us a ruling declining our application and gave orders that the accused person should open his case. And before the opening of the case or otherwise, it was explained to him that he had right to remain silent. He could give a statement or he could open his case. We told the court that we expect the full ruling of the court, give us justification for the refusal, and then we can peruse it, and based on that, we will advise our client to bring an opinion as to whether or not he's remaining silent, he's opening his case, or he's making a statement. So the court has adjourned for 7 days. And don't forget that we have 2 days of public holidays. So they will not count. The weekends will not also count. So we're coming back next Thursday to give our opinion as to whether or not our client will open his case. So don't forget that as part of the responses, we may take a decision to apply or to appeal against the decision. There's a very strong possibility there. So when we have looked at the full rendition of the decision, then we will take a decision as to whether or not we are opening our defense or we are appealing against the decision. That will come on Thursday when we come.
Counsel,
Now,
your preliminary comments or reaction to the ruling and submission of notice, you're expecting that it would basically go in your favor because you had indicated to the court, among other things, that the prosecution hadn't proved enough for him to open his defense, but that didn't go your way.
yes.
What is the feeling like right now?
Yes, that is a decision of the court, and we disagree with it, but it is the decision of the court. So we'll look at the options available to us, including the right of appeal. In any case, to put it in summary, this is a case where an accused person, originally accused person, has now turned to be prosecution witness. Prosecution witness comes to court and says that I committed the offenses under the law. Yet, I am going to testify in support of the prosecution against somebody who did not commit, according to him, did not commit the offense, but facilitated the offense. This is a country, very lawful country, and if this is the way our criminal jurisprudence will turn out to be, that means nobody is safe, because any accused person at all can come and admit the commission of the crime and immediately turn out to be a prosecution witness and call any of us as having facilitated his commission of the crime. And immediately he is exonerated of the crime because he would have signed non-prosecution agreement. And then the person who the offender is saying would have facilitated him becomes the accused person. We live to see. Very interesting times ahead. So let me put that one to a stop. And then let's look at the second case where we finished the case management today. The documents that were not readable, we have replaced them, and that we have completed case management, taking dates for the trial. Indeed, the next adjourned date being 29th of March. So we'll come here on 29th for the first prosecution witness to mount the bus, for him to tender the documents or complete his evidence in chief, and then we will cross-examine. And we've taken 6 hours of cross-examination, broken into 2 hours a day. And that gives us 3 days to finish with the first prosecution witness, who happens to be the original accused person turned prosecution witness. And the principal prosecution witness in this matter. This is the one of the Numeri Forest. So we'll come back on the 29th to start the hearing. 22nd March to start the hearing.
So far, is your team happy with it?